Record the public disclaimer. We'll get started.
Okay. Notice of the December 9th, 2020 meeting of the Real Estate Commission, including date, time, and location, has been noticed on the Tennessee Real Estate website since October 30th, 2019. Additionally, this month's agenda has been posted on the website since Friday, December 4th of 2020. Okay.
The roll.
For the roll, Joe Begley.
Here.
Okay. Here. Commissioner Jeff Diaz.
Here.
Commissioner DJ Ferris.
Here.
Vice Chair Marcia Franks.
Here.
Commissioner Steve Gwynn.
Here.
Commissioner John Moffitt.
Here.
Commissioner Joan Smith.
Here.
Commissioner Stacy Torbett.
Here.
Chairman John Grease.
Here. So we have 9 members present out of 9 possible members present. That's great news. At this point, Stacy, since you offered once, and until you tell me you don't want to lead us in a prayer and the pledge, you've got the honors. So if you would pray for us and everyone else you'd like to mention.
Okay. Bow your heads. Dear Heavenly Father, I thank you for this day, for this opportunity to be together. I thank you for everyone present's health. I just ask that you continue to be with us and keep us all healthy and our families. Give us wisdom and discernment as we hear the information we're about to receive. Help us to love one another as Christ loves us, and be with all of our leaders as they continue to try to navigate this virus and how to deal with it. Just give them wisdom as well. Heal those who are sick and be with those who are hurting throughout Christmas, and help us to just remember you as we prepare for the holidays. In Jesus' name, amen. Okay, I guess we stand up for the pledge.
Yes.
I pledge allegiance to the flag and to the United States of America,
And to the republic.
for which it stands, one nation, under God, indivisible, with liberty and justice for all. I'm a tiny bit afraid that I'm going to forget the words to the pledge, even though I've said it a million times in my life. So if I do forget the words, bear with me.
We'll just assume you hit the mute button. How's that?
Okay, that's good.
You'll be okay. All right, Miss Anna, statement of necessity, please, which we will have to vote on. So listen to the words.
This is an electronic scheduled meeting of the Tennessee Real Estate Commission. Notice of this meeting was posted to the Commission's website on Friday, December 4th, 2020. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code Annotated 8-44-108B2, which states if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code Annotated Section 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by the quorum of members by electronic or other means of communication is necessary. As stated, this is a previously scheduled meeting of the Tennessee Real Estate Commission that is now being held via Cisco WebEx. The purpose of this meeting with members attending by Cisco WebEx is to conduct regular business of the Commission, including but not limited to the Education Report, Executive Director's Report, and complaints. Furthermore, it is necessary for this meeting to be held electronically in accordance with Executive Order Number 16, issued by Governor Bill Lee on March 20th, 2020, further extended by Executive Order Number 65, issued on October 28th, 2020, to ensure government continues to function open and transparently during the COVID-19 emergency while taking appropriate measures to protect the health and safety of citizens and government officials. Voting will be conducted by roll call.
Okay, thank you, Anna. So, commissioners, if you believe that statement of necessity is appropriate, when Caitlin calls your name, you'll vote yes, and we'll proceed with the meeting. If, on the other hand, you don't think it's appropriate, you can vote no, and if a majority vote no, we can just not meet today. So, with that said, Ms.
Anna,
Maxwell.
do we need a motion or just the roll call?
I don't think we need a.
Okay.
I
You
don't.
need a roll call motion to adopt that.
All right, with that said, is there a motion to accept this statement of necessity? John Moffett makes the motion. Joan Smith seconds the motion. Oh, it's on the floor. Is there discussion? I hear none. Caitlin, if you'll call, if you're in favor of the motion, vote aye. If you're opposed, vote no.
Okay. Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferris.
Aye.
Vice Chair Marcia Franks.
Aye.
Commissioner Steve Gwynn.
Aye.
Commissioner John Moffett.
Aye.
Commissioner Joan Smith.
Aye.
Chairman John Grease.
Yes. All right, so the motion passes unanimously. We'll move on with
Forgot
the.
Kate. Does that matter?
Oh, I'm sorry. Commissioner Stacy Torbett.
Aye.
We get a girl that'll pray for us, and then you skip her. Get it?
I'm sorry. That's a eyesight error.
Not a problem. All right, let's move on and see if there's discussion or a motion regarding today's agenda. Marcia.
I'd like to add something to the agenda, perhaps under commission discussion, a nomination for the Bill Toon Award.
Okay. Other topics? With that addition, then is there a motion to accept the agenda?
Motion to approve the amended agenda.
Thank you. Seconded by Joe Begley. Discussion? All right, when your name's called, please vote aye if you're in favor of the motion if the agenda being adopted.
Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferris.
Aye.
Vice Chair Marcia Franks.
Aye.
Commissioner Steve Gwynn.
Aye.
Commissioner John Moffett.
Aye.
Commissioner Joan Smith.
Aye.
Commissioner Stacy Torbett.
Aye. Sorry.
Chairman John Grease.
Yes. Okay, so the agenda is approved and we're ready to move on with business. Next up is to approve the minutes of the November 12th, 2020 meeting. Is there discussion?
Move to approve.
Second.
Second, got a second from Steve. Discussion. So I've asked Caitlin about this. Maybe you'd like to speak to it, Caitlin.
Well, I was just going to note that you had sent me 2 edits for the minutes that we were going to include. The first being to remove the section about instructors, as there were no instructors presented. And then the second was to make note of the formal hearing and the decision at the end.
So, well, the discussion about the formal hearing, will it state the time it started, the time it's ended, and the decision of the commission?
Yes, it can state all of those items.
Good, good. Just because it's a historical day, I want to make sure we get it reported correctly.
Okay, we will
Thank you.
make sure that is included.
Any other discussion about the minutes? If not, I'm going to ask Caitlin to call the roll. If you're in favor of approving the minutes, vote aye. If you're opposed, please vote no.
Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferris.
Aye.
Vice Chair Marcia Franks.
Aye.
Commissioner Steve Gwynn.
Aye.
Commissioner John Moffett.
Aye. Aye.
Commissioner Joan Smith.
Aye.
Commissioner Stacy Torbett.
Aye.
Chairman John Grease.
Yes. So the minutes are approved. The chair is going to exercise just a little bit of personal privilege and say hello to Jewel McKinney, who's on this. You've got your hair done, haven't you, Jewel? You've done something with your hair. Say hi to us. Good to have you on board. All right, next up, a medical waiver request from Louis Del Mazo. Caitlin.
Yes, I'm having some technical issues, but before you have applicant Louis Del Mazo. His license was in retirement prior to expiring. So his request is to reinstate his license to retired and for the additional late fees to be waived. He has submitted a letter to the commission and also a doctor's note. You'll note that we don't have anything in the E&O section or the firm affiliation section or the education section, and that's because he is in retired status or was in retired status prior to expiring.
All right, commissioners, what are your thoughts? Marcia.
I'm wondering two things. How long was he expired? And how long has he been retired?
So he expired on March 8th of 2020. So what is that, 9 months? And he retired his license on 10/30/2018. So he's essentially been retired for a little bit less than one renewal cycle.
So, Caitlin, my question, how often do licenses in retirement expire? Is that a common event?
I don't have, factual information on that. I would say from experience, it does seem like licensees in retirement do come in front of me more often than not, just because I think when your license is in retirement, you're not, actively practicing. And so you might be more likely to forget to renew.
Chairman,
Steve.
question. What are the dues for, or what is the fee for a license in retirement versus not a license in retirement? And what does it actually do for somebody other than, I guess, allow them to put their license back active and not have to go through the licensing procedure again? Is that basically it? So those are about three questions.
Yeah, so the fees are exactly the same. It's still a $75 renewal fee, and then additional late fees if you don't renew on time. The benefit of, I guess, going into retirement is that you're not required to have a firm affiliation. You're not required to maintain your E&O insurance, and you're not required to maintain the education while you're in retirement. Now, if you are in retirement for more than one renewal cycle, then you would have to do 16 hours prior to becoming active again. So if somebody is in retirement for multiple renewal cycles, they'll do 16 hours prior to becoming active again. And they also have to, in order to go back to active, they have to submit E&O insurance, and they have to submit their firm affiliation. So does that answer your question?
Yeah. Thank you.
Yep.
Mr. Chairman,
Jeff.
motion to approve the application for a medical waiver.
Second.
Seconded by DJ Ferris. Now discussion on the motion. All right, since we're ready to vote, when Caitlin calls your name, if you agree with Jeff's motion to approve the request to waive $750? Is that what it is, Caitlin?
It's $800.
$800. You'll vote yes. If you're opposed, vote no.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Commissioner Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. All right, that motion passes unanimously. We're on now to Mr. E. Ross White. Show your face, E. Ross.
Can you see me now, Mr. Chairman?
Wait a minute. There you are.
All right. Merry Christmas to everyone, and hope everybody's staying safe. And my big news is my daughter's getting married this weekend, so pray for us on that. Everybody's going to wear a mask, of course. And for today, I'm bringing to your attention the December education report. And I'm going to present to you D1 through D14 that I have reviewed the providers, the courses, and the instructors. Again, we had no new instructors to present to you.
Move to approve.
All right, a motion by Marcia Franks, seconded by Jeff Diaz, that the the education director's recommendation of courses D1 through D14 be approved. Is there discussion? If not, as Caitlin called your name, please vote yes to agree with that motion. Vote no if you disagree with it. Caitlin?
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. So that motion passes unanimously. We're now on to the executive director's report. Caitlin?
Okay.
Could I go back to Ross White just for a second?
Yes.
Mr. Chairman?
So Ross, this notion that we've given providers that have streaming courses, and I know there's a fancy word to describe the particular type of course, are those providers trying to get approved as quickly as possible for 2021 and 2022, or how's that going?
Well, everything's going pretty much the same as it would. It's just during a period of time where a classroom course is active and or these courses have been renewed, then they'll send me requests to put the course on by streaming method. And that being said, it seems to be going very well and very smoothly. Don't have any reports of any issues.
Thank you, Marcia.
Ross, I'm trying to find it. Somewhere we had a report on the schools, and I'm trying to figure out, was that you were on the executive director's report?
It's included in both.
Okay. So it shows us that about half the people are passing and half the people are failing. But one of the big numbers I saw in there was Tennessee Real Estate Commission. What is that? I mean, what classes is that talking about?
I would assume that's where we're either dealing with the broker course, or that in some manner it's not Tennessee Real Estate Commission teaching a course, but it's rather setting folks up to take the exam. That's what I would assume it is.
Caitlin?
Yes.
Where do I find that list, Caitlin? Is it under? It's not under the education or director's report, but I know I saw it because I wrote them up.
It should have been a separate PDF.
So Marcia, at one point, I think Caitlin explained to me that if someone fails the test and then takes it over again, then that falls under the category of the Tennessee Real Estate Commission. Is that right, Caitlin? Do I remember that?
Sorry, say that again.
So let's say 50% of the people initially fail the test. They take it a second time or a third time. Each of those subsequent tests show the Real Estate Commission as a provider. Is that correct?
No, they would still fall under that provider if they're an initial applicant. The ones that fall under TREC would be people that let their license expire and retest, or out-of-state applicants taking the state portion of the exam, or sometimes the national, depending on what state they're coming from. Those are the applicants that fall under TREC, those that are retesting. So if you let your license expire over a year, we have to set you up to test. Whereas if you're an initial applicant coming in, the provider that you took your pre-licensing education through sets you up to test. And so you would any subsequent would still fall under that provider. It's the retest.
So there were 397 of those people, and 38% of them still failed on the second time. Under
you're talking about what's under TREC?
Mm-hmm.
Yeah, so that would be out-of-state applicants, and that would be people that let their license expire.
So are you seeing a lot of out-of-state people applying?
We always have a lot of out-of-state applicants. I would have to do some digging as to whether that's up or not. I know the last 3 months, I have on my report our trends for initial applications. And those applicants would fall under that section. Out-of-state applicants would. So if you look at my report, let me get that pulled up. The last couple months have been increased. I think probably a lot of that could be due to the pandemic and us not being able to test for the months of April and part of May. But I think it's just something to continue to watch.
Thank you.
Mm-hmm.
Joan Smith, and then Steve.
Marcy, I think one of the questions you were asking about was the PSA report. PSI, I'm sorry, that was a big mistake. PSI report, which was the real estate school summary. Is that what you were looking for?
Yes.
Okay.
Okay, Steve.
I didn't have anything, John. I was just waving at my wife to get me another cup of coffee.
Well, that's pretty important. All right, other questions
About
regarding education. Ross, thank you again.
Thank you, Mr. Chairman, members of the commission.
Have a good wedding.
Oh, thank you.
There's at least one person, a Wayne Potter. Would you mind muting your? We'll get some feedback, and I'm trying to get everybody to mute that's not talking. Thank you. All right. With that said, let's go to the executive director's report. Caitlin.
Okay, I have 2 updates. The first being, some of you might have heard that Carter Lawrence was promoted to the commissioner of the department. Carter was previously the deputy commissioner, and then prior to that was our assistant commissioner. And so I think that has happened since our last meeting. In addition to that, Toby, who was serving as assistant commissioner, has been promoted to deputy commissioner, and he will be over regulatory boards, insurance, securities, and TenCare oversight. And then additionally, we have a new assistant commissioner who some of you may know, especially if you've been appointed as a commissioner in the last year, Alex Martin, who served as the Deputy Director of External Affairs and Director of Appointments in the Governor's Office, has been appointed to serve as the Assistant Commissioner for Regulatory Boards. So he does not start until next week. So hopefully in the beginning of 2021, some of you might be able to meet him at least virtually. So just wanted to update everyone on those new announcements. Toby wanted me to assure you guys that he will still be very involved and that he's not going far, but he has been promoted. Any questions about any of that?
Those are great appointments too. Carter has been a friend of this commission for many years, as has Toby. So we're really happy for both them and Alex. Give them our congratulations.
Yes, will do.
I tried to call Carter, and he's too busy to take calls now, and his voicemail is full. And so it's been nice knowing him. I hope Toby does what he says he's going to do and stay in touch with us. But they get the big head. They get moving up there. Easy for me to say.
I think it would be fair to say that it's a very busy and important job and very time consuming. So the other item, which I had given you guys an update of the Kentucky reciprocal agreement. There have been a lot of questions that have come up within the last week that has made me consider holding this agreement until January. If anybody has any strong objection to that, I'm open to discuss it. We had a question about one, Kentucky has a similar statute to ours that allows an out-of-state broker to work with a licensed broker. It doesn't mean that you can just do business in that state. You still have to do it with the licensed agent. But we did receive some questions about that within the last week, and we were going to provide an additional language on that in the agreement. And then I also received a question about the education piece. Currently, Kentucky requires 96 hours of pre-licensing for their sales associate, which is equivalent to our affiliate broker. And so there was some questions about 2.5. Why would we require additional education? So if anybody has, any questions that came up when they were reviewing the agreement, I would love to hear those. That way, when I bring it back to you in January, we can make sure that we have any and all questions nailed out.
Caitlin, I wanted to ask, have you heard from any other states? It seems like Kentucky's on the forefront of this. I'm seeing that at Arello. Are there any other states that have contacted you about reciprocity?
There aren't. And I do think Kentucky is unique in that they are currently not allowing any experience or education like many other states already do. Like our state, for example, we do allow out-of-state applicants to use their experience and education in order to get a license in our state. So I think I don't know if I would call them at the forefront because they're currently not doing what many states are already doing. but I did reach out, and I don't think I gave her enough time. I know she's a very busy individual, but I did reach out to Ann to see how their agreement is going. And so I figured if we hold off until January, I'll also have more time to hear from her and see how it's going between Ohio and Kentucky. Is anybody opposed to that?
I'd say without objection, Caitlin, let's put that on January's agenda.
Okay. So in January, I'm going to get some clarification on 2.5 and see if there's any reason why we need the additional education when our states are equivalent. And then we'll also add some additional language to clarify just that this is not diminish any other statutes that already exist between both states.
Perfect. Thank you. So you also have provided, as you do every month, written executive director's report. Any particular statistics or numbers you'd like to talk about?
I'm muted. No, I would like to give a kudos to the staff. This is a number that's not actually on my report, but it's a number that I got last night. Currently, we are, the average for an initial application approval is 5.4 days, which is significantly lower than when I started. I think we were somewhere more around 12 days. So for the month of November, the staff approved 543 initial applications in an average of 5.4 days, and 90.98% of those were done online. So all of those numbers are improving for the better. And then there's a new number that we're looking at. So we have a similar thing with complaints, but we have started doing what we call clock stopping action. So if we are waiting on the applicant, we can put the transaction in a clock stopping action. And so that number is meaning it only took 2 days of our staff's actual time to approve the applications. So that takes away, if we're waiting on an applicant to send in their fingerprints or we're waiting on them to send in their high school diploma, it kind of puts a pause on our time that it takes. So that's a kudos to the staff working extra hard and getting applications processed quickly.
Great. So, errors, sufficiency insurance. I've got something to say about that, and you may as well. But maybe a day and a half after I sent by mail my renewal to Rice Insurance, I got an email back from Cindy Rice Grisham that basically said, whatever you do, don't send it by mail because we've got limited staff up here, and it's important to get it posted in a timely fashion that you do it online. So especially if you have, like, you're looking for a endorsement in an additional state like I am, it's possible my license in Kentucky will be canceled because I sent it by check instead of by doing it online. I just hate paying that $3.50 service fee or whatever it is. But if you have agents that you talk with, I tell them to do it online to make sure they get it posted and active as of January 1, 2021. Caitlin?
Yes. I'm glad that you brought that up. I did talk to Cindy yesterday, and so far we have about 9,000 licensees that have renewed through the state insurance program. About 80% of our licensees have the state insurance. So we have about 30% of those that have already renewed. And I think, like you said, Kentucky is currently under a special order where only a percentage of their staff can work in the office right now. So I spoke to Cindy and heard the same thing that John heard, that they're having a much harder time processing those that come in the mail because they are only able to have a small percentage of their staff in the office right now. So if you want it done quickly and want to get to us quickly, it's definitely better to do it online this year. Shout out to Joan. She's already renewed her E&O insurance. She checked with me. So we're going to continue to push out reminders about that. Rice has a reminder going out December 15th, and then we'll continue to update our licensees as well that have not renewed their E&O.
Thanks, Caitlin. One last question I have for you. Are you in the office building today?
I am in the office building today. I actually had to move offices though because they're doing construction, and the office that I'm normally in had some window workers behind me, and it would have been quite loud for everybody.
So what's going on with the state at this point? Is there any light at the end of the tunnel as far as your staff getting back together and this commission getting back together in person?
I do not know the answer to that. I do know that currently our staff is coming in the office to serve visitors. And so for all intensive purposes, our consumers and licensees are still getting the same level of service that they've always gotten. You can walk in and pay in our building anytime from 8 to 1 p.m., I believe it is. And then if you just have a question, you can get that answered anytime after that. But as far as us meeting, I do not know the answer to that.
I didn't think you did. Marcia?
Yes, I want to give kudos to Caitlin and the staff. Yesterday, I was on a Zoom call with the new CEO of Alabama's Real Estate Commission, Vaughn Poe. And Vaughn became executive director there in May of this year. So it was already in the midst of COVID. And he was telling me about what a hard time he was having with some of his staff working from home and getting used to doing things remotely. And so I told him about Tennessee was doing it long before COVID even started, and that everything, all our numbers are up. We're getting the same, if not better, level of service. And he was really surprised by that. And I told him, just keep on. It'll come. But I'm very proud of Tennessee. Really is doing well with this remote situation and with COVID. Thank you, Caitlin.
Oh, yeah, thank you. I think we are lucky that we have a lot of systems in place that allow us to, one, monitor all of our numbers, and then two, from a customer service standpoint, we have a lot of metrics in place that allow us to monitor call wait time, volume, and then monitor the feedback that we're getting on our customer service.
All right. Any other comments or questions for Caitlin? Steve?
Mr. Chairman, I'd like to also give kudos to Caitlin, a new editorial columnist. Her editorial was in our paper over the weekend. It was very well done. So thanks for doing that. Very, very nice job.
Thank you. We had written a blog post on tips for buying a home, and that got picked up by multiple news sources. I was slightly upset about the title that they used, because the title that they used was not the title that we used on our post, and is not something I would have approved if you saw it in the commercial appeal.
Yes.
But yeah. So they took a little leeway on changing that, but otherwise, I think any traction is good traction, especially when trying to protect consumers. So,
well, if it makes you feel any better, I was quoted in an article back in April, and I had a beef with the guy that wrote the article about the headline, and they always do that. I say always, a high percentage of the time they'll come up with a headline that has nothing to do with what you were talking about. And anyway, I've been there, so I know what your situation was.
yes, yeah, it was a good learning lesson. But yes, that article has gotten picked up by the appeal and the Tennessean now. So It's getting good traction.
There's no way to control them on the headlines, though, I don't think. I mean, they're just going to do what they're going to do, regardless of what you say.
So,
Thank you, though.
So where could a person go to read that?
Person could go to the Tennessean, they could go to the Commercial Appeal, they could go to the Department of Commerce and Insurance blog post, and then I believe there is also a Chattanooga news source that also picked it up. So
it was a USA Today affiliated situation, which USA Today controls, I think, the 2 or 3 big papers in Tennessee now.
So I didn't know about the Department of Commerce's blog post. Could you give me a link to that or send us a link at some point, just so we...
Yes, yeah, I can send you a link. So the blog is something new that the department is doing, and I think actually the commission got one of the first articles, and so from there, these news sources asked, can we print your post? So that's kind of how it went.
Got it. All right. Anything else for the executive director? I know all commissioners reserve the right at any time to ask her questions, so it's not important to be done right now. All right. With that said, I hate to say this, but I'm ready to go to the consent agenda. Shalina, if you're ready to go to the consent agenda.
Yes, sir. Good morning, commissioners. This is Shalina Brown, and I will be presenting the December 2020 consent agenda. First, I will put the complaint numbers into the record. The first one is 2020057 Number 2, 2020057 Number 3, 2020058 Number 4, 2020058 Number 5, 2020061 Number 6, 2020055 Number 7, 2020056 8, 2020062 Number 9, 2020062 Number 10, 2020058 Number 11, 2020058 Number 12, 2020060 Number 13, 2020062 14, 2020063 Number 15, 2020054 Number 16, 2020060 Number 17, 2020062 Number 18, 2020056 19, 2020070 Number 20, 2020062 Number 21, 2020062 22, 2020064 23, 2020067 24, 2020068 25, 2020058 26, 2020060 Number 27, 2020059 28, 2020061 29, 2020070 Number 30, 2020064 31, 2020065 32, 2020069 33, 2020078 34, 2020070 35, 2020046 001 36202063 331, 37202065 541, 38202069 861, 39202071 601, 402020 061 41 2020 061 071 42 2020 062 221 43 2020 069 511 44 2020 069 951 45 2020 076 631, and the represents 46 2020 051 321 47 2020 030 081 48 20 18048 611 49 2018 082 141 50 2019 013 541 51 2020 003 801 52 2020 050 351 53 2020 052 531 54 2020 053 461 55 2020 053 321 56 2019 06 0881, and number 57 2019 098 741.
Thank you, Shalina. 57 cases compared to 80 some odd last month, so we appreciate that. Thanks very much. We have, at the request of all parties involved, 18 cases that I'm aware of at this moment that need to be pulled from legal's recommendations. So I'm going to read these cases, and then if other commissioners or any commissioner has other cases they would like to add, we're happy to do that at this point. You all should have received an email from Caitlin this morning with the same list I'm about to receive. Case 5, 7, 8, 9, 12, 16, 21, 22, 23, 25, 27, 28, 35, 36, 46, 47, case 52, and case 55. Are there other cases any commissioner would like to exclude from a motion I'm about to ask for? Joe?
On a side note, I did not get a list from Caitlin. I don't know if something's wrong with my email or
perhaps it didn't go to
everybody
everybody.
else get that?
I guess I got it. So,
No, I just sent it to our legal. I just compiled the cases.
everybody, it's hard for me to tell who gets what. That's my fault. Okay. Any other cases, Steve?
This might be a correction, but on number 39, the first sentence, it mentions 2 complainants, and I'm thinking the second mention there should be respondent. And I don't know if it's a technical correction, or I have no problem with the recommendation. I just thought it might be incorrect. Am I wrong on that?
I think.
Commissioner, that's correct. That's my error. It should read complainant is a Texas resident and the respondent is yes.
All right, cool. Thank you.
Thank you, Steve. Other questions or cases to be pulled? If not, is there a motion to approve council's recommendation regarding cases 1 through 57 with the exception of the 18 cases that I've just referenced?
Move to
Opposed.
Stacy Torbett makes the motion. Is there a second? Jeff Diaz seconds. Now discussion. Marcia? Okay. All right, if you're in favor of that motion, when Caitlin calls your name, you'll vote yes. If you're opposed, please vote no. Caitlin?
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
I think Jeff said yes.
Yeah.
Okay. Commissioner DJ Ferris,
Yes.
Vice Chair Marcia Franks,
yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. So that motion passes. We're now on to case number 5. This was pulled by Ms. Franks. Marcia?
Yes, this is the one where let's see, where I'm trying to remember, was it the wife or the husband? There was only one person.
It was
That's-
the wife.
Okay, so the wife is the only one on the deed. So is there not a marital ownership that a realtor or a licensee should divulge? Or how does that work?
Well, the respondent was the listing agent and was not the owner, so there was no requirement that the respondent state that he was the owner agent because he was not the owner agent. Unless that deed was quit claim to him and he was on the deed, then he was not the owner, technically.
So a marital interest would not affect this then? I wasn't sure about that.
No, it should not, unless it was on the deed, his name. He was not the owner agent.
Okay, I move to close. Accept council's recommendation to close.
Jeff Diaz seconds the motion. When your name is called, if you're in favor of the motion, vote aye. If you're opposed, vote no. Caitlin?
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks, Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. So that motion passes. Next case is case number 7. DJ, you want to speak to this first, then Marcia?
I did not have that one on my list.
Oops. I'm sorry, Joan. My fault. Joan, did you want to speak to this?
I did. I had this one on my list, and this was a pretty long one. And my concern was if legal was satisfied that the respondent assured, if you were okay with the change of the confirmation of agency, that change in relationship was done properly. And if legal is satisfied with that, then I'm okay with the decision, with the recommendation. It's just that as I was reading with that and the way that the respondent converted the relationship from in the confirmation of agency, and then they went to facilitator. And I was just wondering if legal was okay with the documentation, with the way that relationship changed.
Yes, Commissioner, when I reviewed this case, it was very apparent to me that many of the allegations made by the complainant were incorrect. There was proof provided by the respondent showing that that the respondent was not the facilitator, and there was no documentation supporting that. So many of the allegations were not true. And I didn't find anything that the complainant said was correct based on everything the respondent provided. And it was a little surprising that all the allegations were wrong, but I think there was a misunderstanding by the complainant about the role of the real estate agent in the situation, and they just didn't understand what was going on.
Okay. Okay.
So my concern was there a confirmation of agency that was signed by the both parties moving from a single agency to a facilitator?
There was no facilitator status by the respondent. It never occurred. There was no documentation showing that.
Okay. So there was a separate person who was the buyer's agent?
Yes, that's my understanding.
This was not a dual agency.
Go ahead.
I'm just making sure this was not dual agency.
No, there was no dual agency situation.
Okay. All right. Well, that was my question, and I'll move to accept council's recommendation to close.
All right, a second of mine. Joe Smith, right, Joe?
I see Joe has his hand up.
Yeah, he's seconding the motion.
John,
Yes, Joe.
this is not supposed to, this isn't funny, but what's alarming is they purchased the Glade plug-ins, which, you know, if you're trying to cover up smells, buying stuff for a seller, that's more alarming to me than anything. I'm not trying to be funny. I'm just serious.
I got it. So I did put you down as seconding the motion, Joe. Is that okay?
Yeah, perfect.
All right, just making sure. All right, the motion is to accept council's recommendation on case number 7. If you're in favor of that motion, when your name is called, you'll vote yes. If you're opposed, please vote no. Caitlin?
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith, I think you're on mute, Joan.
Aye. Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. So that motion passes. Next up is number 8. Jeff, you want to speak to that?
Yeah, I do. This one is, you know, I guess a trap that some agents fall into where they use photographs for new listings. You know, at first I leaned towards accepting council's recommendation, but then I saw that it was a principal broker. And to me, getting new photographs just seems like it's real estate agent 101. So I'd like to make a motion to just send this agent a letter of warning, reminding them of their obligations to reasonable skill and care.
All right. Is there a second to that? Marcia?
Yeah, I'll second it. But I also have a question too. If we could amend it to say that they take the principal broker core class, because that's what I picked up on too, Jeff, is that this was a principal broker, and obviously they didn't even go in the house before listing it. Surely they would have noticed there were no appliances.
Jeff, you okay? Okay. Okay, so at the moment, we have a motion on the floor made by Marcia Frank, seconded by Jeff Diaz. If passed, would ask legal to send a letter of warning discussing reasonable skill and care requirements, and also require the respondent to attend a principal board or core class. Discussion on the motion. DJ.
I support the letter of warning I'm not yet convinced that the course class is needed, but I'm open to hear more thoughts. But thank you for proposing it.
Other discussion? All right, are you ready to vote? I think so. Let's do it. If you're in favor of the motion, remember letter of warning and requirement to attend a principal broker's core class with the conditions we typically put on it. I assume, Jeff, 180 days to get it done. The course does not count toward any other continuing education requirements. Caitlin?
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
No.
Vice Chair Marcy Franks,
Aye.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith, I think you are on mute, Joan.
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. All right, next case, number 9. Jeff?
Yeah, Shalina, the only question I had for this case was, so was the license never expired, or was there a point where it was expired? And if so, was the transaction occurring during the time the license was expired?
Yes, I believe the license was an expired grace status, and during that time, the respondent renewed the license.
Okay, and so Caitlin, expired grace, does that allow them to continue to practice? Remind me.
It wasn't clear from the complaint that there was any transaction involved in this situation.
I see. Okay, and motion to accept council's recommendation.
Seconded by John Moffett. Discussion. Let's vote. Caitlin, if you're in favor, vote aye. If you're opposed, vote no.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marsha Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. All right, thank you all. We're on to case number 12.
Commissioner?
Yes.
Excuse me, Commissioner, if we could go back to number 8, you had stated you'd like the commission voted to have a letter of warning issued and the 8-hour principal broker core class. If we're assessing some sort of discipline, I believe it would be more appropriate to authorize a contested case proceeding and issue a consent order requiring the 8-hour principal broker course, because upon issuing a letter of warning, the matter is closed.
So I think both the maker of the motion and the second would agree to that stipulation. So we're taking the letter of warning off the table, if I'm right, Shalina, tell me, and only requiring the broker to take the principal broker's core class.
Yes.
And if he doesn't like that, then we'll have a formal hearing to discuss it.
Correct.
Jeff, are you okay with that? Okay. Can we do that without objection, Shalina, or do you want another vote on it?
I believe the commission should have a vote on it.
Okay, and the chair is going to consider, we had a motion to reconsider that was okay without objection. So now we're going to go back to case number 8 and re-vote on it, where the motion in front of commission is simply to require the respondent to take the principal broker's core class within 180 days. And again, that education does not apply to any other education requirements he or she might face. All right, everybody clear? All right, Caitlin, let's vote on this again. If you're in favor, vote yes. If you're opposed, vote no.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
No.
Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. All right, that motion passes. Thank you, Shalina, for pointing that out. Let's go to case 12. Joan, you want to speak first on this?
And mine was mainly a question is, it seemed like the argument was whether or not the agent was responsible for collecting the rent on this. Is that common? Is that something the respondent was, is that an issue here?
No, actually, the respondent was doing this as a favor for the closing agent, just mailing this. It wasn't the responsibility of the respondent to send the monies and was not collecting the monies. They just mailed it. They just happened to mail it by regular mail and it got lost. So the complainant didn't receive it and was upset that the respondent didn't take responsibility or reissue another check, but it wasn't up to the respondent to issue the check. It was from the seller.
It was from the seller. Okay.
Yes.
Then I make a motion that we accept the legal recommendation to close.
Joe Bagley, seconds. I want to hear from Jeff first.
All right, so it seems to me you're saying that the respondent didn't have any contractual obligation to the complainant?
Correct.
Okay. Then I'm okay, John, thank you.
All right, the motion on the floor is to accept council's recommendation. If you're in favor of that motion, aye. And again, I'm getting some feedback, so if you're not talking, please mute your mic. If you're in favor of the motion, vote aye. If you're opposed, no. When your name is called, Caitlin.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. All right, that motion passes unanimously. Number 16. All right, so this is a case where somebody has a billboard and they have a guaranteed offer program. And this says it's subject to terms and conditions. Well, they don't get that latitude in my mind. The billboard has to have all the terms and conditions spelled out. And more and more I'm hearing people saying, if I don't sell your home, I'll buy it. And that advertisement has to have all the terms and conditions. You can't just say that. And it's clear that I think our rules that that's the case. So in this particular case, because the billboard does clearly state the offer is subject to terms and conditions, and those terms and conditions aren't itemized, I think this respondent is guilty of violating a rule, at least a rule of ours that has to do with promotions. What is that rule, Anna? Do you recall off the top of your head?
Hold on one moment. you talking about a specific advertising rule?
No, it has to do with prizes, promotions, I
Okay,
think.
gifts and prizes. Sorry. Okay, I was
Yeah.
very confused.
Oh.
The gifts and prizes rule is 126002-.33. And the specific provision that I think you're speaking about would be that it in writing all the disclosure of all the pertinent details, including any requirements which must be satisfied by the prospective purchaser or lessor.
Yeah. And so that's what I'm hanging my hat on this one. I think that anybody that advertises some catch or hook to get you has to put all the details of that hook in the ad. You can't just give it later. Anyhow, hold on.
And John, this is a firm too, so we need to figure out instead of the respondent being a person, it's the firm. I always have problems dealing with the firm and what penalties to give a firm, because who is that person that's going to get the penalty?
Well, since the complaint's filed against a firm, we really have no choice in a case like this. And if it's a typical case, the first advertising violation, if we want to consider this an advertising violation, is like a $500 civil penalty.
Well, and it also goes to the principal broker had to have been the person who approved the advertising, and especially something as big as a billboard, you would think, and as costly as a billboard is, they would have gotten permission from a principal broker. So there may be something that we need to open a case on the principal broker. That's up to you.
Pardon me.
That's up to you, though, your motion.
I don't make motions as a rule. So the floor is open. If somebody, DJ?
I was going to ask council to walk me through why they recommended to close it.
The main reason was because it said subject to terms and conditions on the ad, on the billboard. So that's why I recommended that it be closed.
Thank you for that. I feel like I see that all the time, and that it's just become a part of our that's become a part of our expectations with marketing and with some companies that there's going to be terms and conditions that the consumer has got to look into. However, I hear your concern, Chairman. I'm all ears right now.
I'd like to understand it better too, John. Subject to certain terms and conditions is typical, business statement. I mean, are you saying that that's not enough detail, that they should put the terms and conditions on how they would buy a house on the billboard?
So, yes. I mean, that's what our rule states. It's not like it's my interpretation. The rule's pretty clear on it. For instance, if somebody says, if I don't sell your home, I'll buy it, but there's some conditions like it has to appraise. I'm going to offer you 80% of the appraised value, and you have to get a home inspection. You have to do all the repairs. You have to agree to do some owner financing. Whatever those are, those need to all be listed. That's what our rule says. It does. There's no latitude as far as anything. I mean, it's not like subject to terms and conditions. And Anna, you might read that again, just
Okay.
now that we're talking about.
So actually, I misspoke. The rule, it does fall under advertising. So if you have do you have your green book with you? Does anyone? Okay. So I would turn to, hold on real quick.
Tell us the page number, Anna, if you would.
Yes, if you will turn to page 83. in your green book, if you have it with you, it's going to be under advertising. So section 7 specifically talks about guarantees, claims, and offers. And if you look at B, 7B, it says any offer, guarantee, warranty, or the like made to induce an individual to enter into an agency relationship or contract must be made in writing and must disclose all pertinent details on the face of such offer or advertisement. So my interpretation would be if there is an advertisement, it states here that on the face, the offer must be put on this specific advertising.
Joe?
Yeah, and Steve, I think, John's point, and I know my point is, we're supposed to be overseeing a professional group of people, and we want to try to keep it professional, and we don't want it to turn into, car sales in the sense of, and the rest of us are playing by the rules is the problem. And these people push the boundaries and don't play by the rules, and then they just get their hand smacked a little bit. And as someone said it before many times, I think Marcia's, always saying, if they're making $10,000 a month on something that's on that gray line or on that pushing the gray line, and every month we give them $100 fine, they just call it, it's cost of doing business. So, we have to be pretty strong with these people, or our industry just turns into something, we don't want it to, maybe. So
I guess the only thing I was kind of thinking is the impracticality of putting terms and conditions on a billboard, all the things, 80%. I mean, you can't read it. I mean, it's not practical. So I would think you would just say, you know what, we can't even have that on a billboard. I mean, I know that's not what the rule says, but I would say it's not fair to put any kind of an offer on a billboard, like what we're talking about here. But that's just my opinion.
Because we're trying to protect the public. That's our number one job, is protecting the public. And there's a lot of people that are suckered into this. I get something every day in my mail similar to this. But when it goes to, it's on a billboard, maybe that principal broker should have had some second thoughts about that and maybe called their attorney or looked it up in the green book themselves, because it is clear and doesn't leave us much latitude, in my opinion.
What we're saying then is that you can't put subject to terms and conditions on a billboard, essentially, is what we're saying, correct?
I think what we're saying is if you're going to offer an inducement, you have to describe the terms of the inducement on the front page, whether it's a billboard, a mailer, a radio advertisement. That's what the rule says. And there are a lot of people, even in my market, or at least in my market, that are every day telling people if they can't sell their home, they'll buy it. But there's strings attached to it, and they don't tell you what the strings are. And
well, shouldn't we be more clear on this point? Meaning, it's not okay to put a blanket statement on anything that says subject to terms and conditions without, we're all perfect. We're not going to buy any of this line, but obviously the public doesn't know that. So I just don't know that it's clear enough what we have to put and not put on a billboard or an advertisement. I mean, you're not going to put, 10 points of a contract on a billboard.
Well, I would just like direct Steve, back to the specific rule. So it says you must disclose all pertinent details on the face of such offer or advertisement. So if it's someone, you obviously aren't going to put the whole contract on a billboard or any of the advertisements, but any of those things that you would normally look at that would change somebody's perception of what they think, what made them enter the contract needs to be in there. So not the small details, but big details like this are supposed to go on. And understand that it may seem impractical for a billboard, but that's just kind of how the rule, that would require a rule change. And we
Well-
have to reorganize what is considered advertising materials and what is not considered advertising.
If I was the, I think you could get into an argument over the word pertinent then, because if I'm the principal broker, I'm saying, look, I put the pertinent details on the billboard. It's subject to terms and conditions. That's pertinent. I don't know if that wins or not, but if I were the broker, I'd probably say that and say, okay, fine, let's get into a discussion on it. I mean, I don't know what the word pertinent means in the context of that rule.
DJ?
Inform me here too, Anna, about the rule. I'm reading the rule again. And I'm reading it from a standpoint of if I'm seeking to induce an individual to enter in an agency relationship or contract with me, not even about me buying their house. Are those two separate things? Or does this rule apply to both?
Well, the rule says you must make to induce an individual to enter in an agency relationship or contract. So I guess this is another thing, like Steve was saying, is a matter of interpretation. But I would think that must be made in writing, pertinent details, an agency or relationship or contract I don't think there's a way we can separate you from that, if that makes sense, from your business. And maybe I'm not understanding it correctly.
I guess I was thinking, like, if I'm gonna, I've never done this, but I'm just trying to think if there's any offer or guarantee I'm gonna put out to get a individual to sign a buyer's agency agreement with me, or a contract to represent them as their broker to list their property. That's how I'm reading the rule.
Mr. Chairman, I'd like to make a motion.
Please.
I'd like to make a motion that we assess $1,000 penalty for this breaking this rule of conduct, 1260.02.12.7B, and that we also open a case against the principal broker.
Okay, is there a second to the motion? Jeff Diaz seconds the motion. We'll discuss the motion, but if it's okay with both the maker and the second of the motion, I'd like to divide the question so that we can handle the current complaints and then talk about opening the next complaint. Is there discussion on the motion? If not, I think we're ready to vote. If you're in favor of the motion, which if passed would offer the respondent a $1,000 civil penalty, you'll vote yes. If you're opposed, you'll vote no. All right, Caitlin, let's call the roll.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marsha Frank,
Aye.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffitt,
Aye.
Commissioner Joan Smith,
Yeah.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes, so that motion passes. Now, to Marcia's point, the complaint was filed against the real estate firm that we just heard. And she has made a motion at this, made a motion and a second by Jeff that would open a complaint against the principal broker for failure to supervise. I guess, Marcia, is that what your sense is, Jeff? Okay. So if this motion passes, and we can discuss it if anyone would like to, you would authorize staff to open up a complaint against the principal broker of the real estate firm we just offered a consent order to. Discussion? All right, let's vote. Olin?
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes, so that motion passes. Let's do this with, unless there's an objection, let's take a break, come back at 5 minutes after the top of the hour, and we'll start back with case number 21, Marcia. See you in about 8 minutes. Caitlin.
Hey, I'm here.
Let's just, since we're reconvening, you want to just do a quick roll call for the record, make sure we've got a quorum.
Yes, we'll do. Joe Begley,
Here.
Jeff Diaz,
Here.
DJ Ferris,
Here.
Marcia Franks,
Here.
Steve Gwynn,
Here.
John Moffett, Joan Smith,
Here.
Stacy Torbett,
Here.
and you're here as got
Here.
you.
Yes, thank you.
Mhm.
Okay, John will be back momentarily. In the meantime, Marcia, let's go to case 21.
Okay, this is a case of a principal broker who was dealing with the listing of a home where a divorce was taking place. So evidently, according to this, the wife was left out of all the agreements, and for some very strange reason, there was a vote of the licensee and the husband to make the decisions about the property without the wife. And the respondent was saying that they didn't know about the marital dissolution agreement until June 8th of 2020. So I'm just wondering, from a principal broker, maybe they kept it a secret from this person, but I'm a little worried that a little more should have been expected from a principal broker, and especially one that's had a history of consent orders in 2014 and 2017, to be a little bit more aware and on their toes about this. So I guess my question is, did they provide the marital dissolution agreement to TREC? And is there any way of knowing, well, obviously the wife said that, that she didn't get to have her say in this. So I'm wanting to be sure about this, Selena. Could you just give me a little bit more of what they gave you that would make you think that this person was not responsible?
Sure. When the parties listed the home for sale with the respondent, there was no indication that they were going to be getting a divorce or planning for it or anything like that. But after it was listed for sale, I guess the divorce proceeding was filed and the marital dissolution agreement was entered by the court, stating that when there's a discussion concerning or any consideration for changing the listing price, repairs, improvements, or acceptance of the offer for the sale of the home, there would be a three-way vote between the parties, and it included in that three-way vote the respondent as one of the voting individuals. So in this case, what happened was the emails did not get to the wife concerning the reduction in price. Initially, there was a suggestion by the respondent that the price be reduced by $55,000, and the wife refused that. And then it appears after that there was another reduction in price suggested of $50,000, which the wife was left out of the email chain because there was a wrong email, and her vote was not considered, but the husband and the respondent broker made the vote to reduce the price by $50,000, and that's when the wife learned of it from a friend that the price had been reduced by $50,000. But because of that marital dissolution agreement stating that there's only 2 individuals needed to vote on the reduction in the list price, that's why there was no issue here. And the marital dissolution agreement was provided, but it appears the respondent learned of it from the attorney for the husband shortly after the wife had refused the initial reduction in price by $55,000. So that's when on June 8th was when the respondent learned of that reduction in price. I'm sorry, of the marital dissolution agreement, and that was following the initial request to reduce the price.
So it's a copy of the marital dissolution agreement.
Yes.
And so that's what it says, that there'd be that three-way vote.
Yes, and that was a little unusual to me as well, because I've never seen something like that included in a marital dissolution agreement. But apparently that was to avoid any controversy in terms of having that property sold, because often that's an issue in divorce proceedings.
So I would think that it would have behooved this principal broker, if there's something as important as a price change, and I sent that to you by email, I would ask that you respond back so I know that you received it. And if you didn't, by the next day, I'd be calling you. So I don't like the excuse of I sent an email and they didn't get it, or I had the wrong email address. Because surely they had the phone number of the 2 people selling this house. So I don't know. What does everybody else think?
So my thoughts were both the husband and wife's divorce attorneys we're playing pretty loose to let the real estate agent be the deciding vote. And if I was a real estate agent, that's the last thing I'd want to be, is a deciding vote in a situation like this. It's, as Shalina said, as unusual as anything I've seen. I wouldn't want to get put in that position. That's the last position. I don't know if E&O insurance covers some sort of position like that. But it's hard for me to fault the broker when the attorneys allowed the situation and the judge allowed the situation to occur.
Okay, then I'll make a motion that we accept council's recommendation to close.
Seconded by Jeff Diaz. Discussion. If you're in favor of the motion, please vote aye when your name is called. Opposed,
Commissioner
no.
Joe Begley.
Aye.
Commissioner Jeff Diaz.
Aye.
Commissioner DJ Ferret.
Aye.
Vice Chair Marcia Frank.
Aye.
Commissioner Steve Gwynn.
Aye.
Commissioner John Moffett.
Aye.
Commissioner Joan Smith.
Yes.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. Motion passes. We're on to case number 22. Joan, this is one of yours. Tell us what do you think about
Only one that pulled.
It's okay to be the only one.
Well, and I was just confused. It was just all over the place to me. And yes, did anybody else feel the same way when you read this one?
Yes,
Hey,
I
Joan,
did.
Joan and Steve, let's let Shalina give us the capsule version of what's going on here.
Sure, yes. This was a pretty confusing one. The complainant and the buyer were in a agreement, a buyer's agreement. The complainant was representing the buyer, who also happened to be the ex-husband of the respondent. So, yes, the respondent entered into, I guess, an agreement with the complainant. So there was a dual agreement going on, and the respondent was aware of the prior buyer's agreement with the complainant and still went ahead and represented the buyer in the transaction, which was the ex-husband. So that's why there's a violation here. Because essentially this respondent did, take the client and enter into a transaction.
Could I ask why is the complaint filed?
Oh, the complainant is seeking the commission from the sale. The complainant who represented the ex-husband, the complainant real estate agent, had a buyer's agreement with the ex-husband, and then the respondent real estate agent entered into a transaction with that ex-husband and purchased a home and did not give any commission to that complainant who had the buyer's agency agreement.
That's where I couldn't figure out what the complaint was.
So, complainant is also a licensed real estate agent. Is that right?
Correct. And
Yeah, we didn't get that
represented
information.
buyer.
And the husband, the ex-husband, is he a realtor too?
No, he is not. He's the buyer of the property.
Okay, but the wife, and she's neither the complainant or the respondent. She just wouldn't sign
No.
the papers, right?
The wife was the respondent real estate agent who also represented the buyer, the ex-husband, and then helped to find a home, and they purchased a home and didn't share that commission. There was an existing buyer's agency agreement with the complainant that the respondent interfered with.
Thing needs a flow chart. Good night.
This is much like the
Shalina.
previous one. When you get in the middle of the divorce stuff, you just can't. There's three sides to every story, and it's hard for us to decipher.
So,
Yeah.
Shalina, your recommendation is a civil penalty because it's your belief the respondent counseled client on how to break a contract.
Yes.
And can you document they did that?
Yes, because they were aware of that previous buyer's agency agreement with the complainant and went ahead and still represented the ex-husband buyer in another transaction.
Is that the only thing that you see, that line that was crossed in this complaint?
Yes.
Okay.
Must have held him hostage because she wouldn't give her tax returns until he used her, correct?
Correct.
My last question is, was the property that he ended up buying, did the complainant ever show that property to him? Was he or she the procuring cause of that particular property, or was this a totally new property?
This was a different property.
How much was the commission?
Oh, I'm not sure. I have to look that up.
Good question, Commissioner Begley.
So if we do this $2,000, that goes into our fund. The complainant still doesn't get anything, correct?
Correct.
And so, Shalina, you're saying $1,000 for each of those violations, correct?
Yes.
So you only saw 2 violations, is that correct?
Yes.
Okay, that was my question earlier. How many violations did you find? And you found 2, is that correct?
Yes.
So Joan, are you looking something up, Shalina?
I'm trying to find the commission amount.
So while Shalina does that, Joan, do you want to make a motion?
I make a motion that we accept council's recommendation.
We'll hold the vote until we hear his answer. Marcia Frank seconds the motion. That's what will be in front of commission for vote shortly.
I had a hard time reading this one.
Me too, Joan.
You're not the only one.
The only thing that is unusual, I think, in the last paragraph, it says that the respondent, that the ex-husband did provide the respondent with the buyer's rep agreement, but it was not signed.
Right, I saw that.
It actually was signed. The copy that was submitted wasn't signed, but there was a signed agreement.
So did you see that, Shalina?
Yes.
Why did they not provide it then?
I think they just provided the unsigned agreement for whatever reason. There was a signed agreement.
But you did get a copy of the signed agreement?
Yes.
Okay. In this situation, since the complainant was a licensed realtor or real estate agent, would that have made a difference if you had had that in your in the header for us, or you couldn't have put that there for us?
Yes, I will. Next time I will include that in the initial paragraph describing who the parties are. So it's clear. This was a little confusing.
I apologize. I thought I was paying attention, but what are we waiting for?
So Shalina is trying to answer Steve's question about how much the commission was that's in dispute.
It looks like the purchase price was 200,000.
So you could assume, I guess, Steve, half of that times some split in the company times some percentage rate. It may show up here in a closing statement, but
I'm just wondering if the respondent is facing a $2,000 fine, if he's not better off just to offer $2,000 to the person that thinks that he or she should have gotten a commission and call it a day. And people, I don't know. I'm just.
Here,
we can't give that penalty to them.
I know.
I wish we could.
Here's another oddity that what we may have talked about before. Once a complaint is filed, nobody can withdraw it. If the person makes a complaint today and wants to take it off the table tomorrow, we're still going to hear it. They can't. Steve, are you comfortable voting on this before you hear this number?
Well, I got a sense as to what the number is.
So
I mean, just doing a quick math deal, it's probably let's see. Let's call it, I don't know, $3,000 maybe. Okay, that's fine. Yes.
All right. Thank you, Shalina. Okay, the motion on the floor is to accept council's recommendation, which, if the respondent agrees to, would offer a $2,000 civil penalty. If you're in favor of that motion, when your name is called, please vote aye. If you're opposed, vote no. Caitlin.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. So that motion passes unanimously. Next up is number 23. Martha, Joan, and the chair each pulled this one out. So let's start with Marcia on this one.
Okay, so my concern with this one is that the request for the return of the earnest money was made on April 8th, and it was not returned until June 5th, making it too long. I know they use COVID as an excuse, but I'm sitting here in quarantine and I'm still running my business, and I had to, when I came home, bring checks, and I have my accounting online and where I can take care of things, even from my home. So the COVID is no excuse for this taking so long to get the money back to the people. And that's my concern. And it's supposed to be done immediately and without unreasonable delay. And I think that nearly 2 months is much too long.
You're muted, John.
I'm sorry, Joan. Your thoughts?
I had that, and then I also was about the middle of the first paragraph. The complainant was also not advised the respondent had gone from being the designated agent for the seller to the facilitator. So I'm assuming they were not notified of the change of status.
All right. Thank you. And the reason that what caught my attention was this is an earnest money complaint against the affiliate broker. I think it's open to the wrong party. The complaint should be against the principal broker of this firm, not the affiliate. And so, as I look at it, this complaint opened against the principal. Who's in charge of that earnest money disbursement?
John,
Yes, Joe.
you're cutting in and out on my end. I don't know about anybody else.
Wonder what that means.
I think it might help if everybody else mutes while John's speaking.
Okay, Joe, if that's better, let me know. My point is the complaint was opened against an affiliate broker related to an earnest money return, when in fact it probably should have been opened against the principal broker who controls the earnest money account. So my thought process is dismiss this complaint and open an account, a complaint against the principal broker. Marcia.
So, John, I think this is twofold because they weren't told, this affiliate broker did not divulge this change of status also. So that is something that this affiliate broker is guilty of. And then also open a complaint against the principal broker is what I'm thinking.
And the floor is wide open for a motion or motions of any type.
Well, the reason I'm not so anxious to jump into that is reading it, I was very confused. So the complainant was the seller. Is that correct? And then, so the earnest money would have been held with the real estate company. Now, did the agent make a mistake and not deposit? Yes, but how it cost them $10,000 to not have earnest money deposited in the real estate's escrow account, I just can't wrap my head around.
So, sorry, there wasn't a connection between the earnest money and the loss of that $10,000 regarding the septic system. They were unrelated. And therefore, my recommendation was just to issue a letter of warning because of the escrow amounts not being deposited properly. And their reason was because of COVID. And I gave some consideration for that COVID, for the COVID pandemic and their shutdown of their offices.
What about the change of status, Shalena?
Yes, the change of status was actually obtained late. It was obtained twice. The first time, apparently, it was not received, and the respondent had to get the signature of the seller again on that change of status. But it was submitted.
And signed. Signed too, right?
Yes.
Okay, I will make a motion that we accept council's recommendation of a letter of warning to the respondent. But I also, and it's not concerning the escrow account, as let me just start over. Let me take this back. So this is not the recommendation of council, but I will make a motion that we have a letter of warning concerning the change of status, and then we open a case against the principal broker concerning that it took too long for the escrow amounts to be both deposited and returned. Does that make sense? Or did I confuse everybody?
I don't know if there was a need to return the escrow monies since the sale was consummated. There was a transaction that occurred. So it was the deposit of the earnest monies that did not occur promptly.
So Marcia,
Yes, sir.
you have one motion that, if passed, would have staff send a letter of warning regarding change of status and agency relationships. Is that one motion?
Yes, and Shalina, is it a second thing though that the affiliate did not turn the escrow money in on time?
I believe it wasn't received and deposited on time because their office shut down.
Okay, that's not really a reason in my book. So I would send a letter of warning concerning the change of status, and then I'll make another one about the principal broker.
Okay, so the motion's on the floor. If I get a second to it. Is there, Jeff Diaz seconds the motion. Would, if passed, authorize council to send a letter of warning regarding agency and its and differentiating the different types of status that you might be involved in. If you're in favor of that motion, when your name is called, you'll vote yes. If you're opposed, you'll vote no. When the vote is over, Marcia, you'll have the floor again.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith, Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. All right, that motion passes. Marcia?
I'd like to make a motion that we open a complaint against the principal broker for the mishandling of the escrow money.
Is there a second? Second by Steve Gwynn. Discussion. All right, when your name is called, if you're in favor of that motion, please vote aye. If you're opposed, vote no. Caitlin.
Commissioner Joe Begley,
No.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. Motion passes. We're on to number 25. But Marcia, I think you pulled.
Yes, that's me. I agree with Shalina's recommendation as far as the respondent did not respond, but I'm also wondering too that these people were shorted money from this California corporation, because that's the real estate firm is a California corporation. They were also charged for new carpet and blinds, and denied their final walkthrough. So I'm wondering about this firm from California. So I agree on the consent an assessment of a civil penalty for that failure, but I'm also wondering about, they also kept money for the carpet and blinds. and didn't allow them to go through the walkthrough to see it. So is there anything that we can do about that, Shalina?
Well, until we receive a response, I would hesitate to take any action on that to find out what the details or circumstances were, and what monies exactly were not returned.
Okay, so if we just give them the $1,000 failure to respond and they accept it, then they don't come back before us about the carpet and the blinds. And the reason I'm stuck on carpets and blinds is those are very big expenses for someone to have to pay for a new carpet and blinds. So if we do this, would the complainant have to file another charge, or how, if that wasn't fair, that they were denied a walkthrough, is there anything that we can do for that person, the complainant?
Now, if the respondent accepts the consent order and pays the civil penalty, then it would be closed. However, I hesitate to make an assumption that they, didn't return these monies and were what the allegations in the complaint are not even addressed or responded to, meaning we're taking it at value that it's accurate.
Well, and I would say to that point, it's, this person's probably going to get off on $1,000 failure to respond, but the darn carpet and blinds cost more than $1,000. So it's cheaper for this person to not respond at all and maybe pay the $1,000 or not. Who knows if they will or not.
Marcia, I understand your point. If everything the complainant said is true, we have no authority to assess a penalty or to reimburse the complainant.
Okay, so this is, as my husband would say, one of those, it's easier to get forgiven than to get permission kind of things to me. Stacy has her hand up.
Stacy.
Well, if they get the $1,000 penalty for failure to respond and there's no resolution to the original complaint, can the complainant refile?
You're saying if they pay the civil penalty and agree to the consent order, or?
Yeah, if they pay the civil, I think this goes along with what Marcia was asking. If they pay the civil penalty, so if they pay the civil penalty, can the complainant refile to say that they basically think they were defrauded of the money for the carpet and the blinds?
Yes, the complainant could refile another complaint saying that they didn't receive those monies back that they were due. But it would be, incumbent upon the complainant to file another complaint with the commission.
Shalene, I would say that the commission doesn't have the authority, like the chairman said, to reimburse for those expenses.
Correct. We can't reimburse for those things, but it could be a violation if they didn't return the security deposit monies that were due to the complainant.
So it might be helpful, Marcia, it might be helpful to add a physical skill and care charge.
But can we do that if they haven't responded?
Not responding and not exercising reasonable skill and care when it comes to the security deposit seems to me.
I like that, Jeff. Okay, so I'll make a motion that we accept council's recommendation and that we also assess a civil penalty of $1,000 for Okay, I'm going blank here. What did you say, Jeff?
Failure to exercise reasonable skill and care.
For lack of reasonable skill and care. So that would be.
Throw some education on there to boot.
Okay, so this is a real estate firm. So a real estate firm can't take education. But, there could be something opened up against the principal broker also.
So I kind of think counsel might say, until we hear from both sides, it's difficult to assume failure to use reasonable skill and care.
That might be their opinion, but again, they were given their opportunity to respond.
Correct. So, Mark,
I'd say let's go with it and see what happens.
I'm going to go with you, but I want to state the motion and see if you've thrown the education in on it.
I'm not throwing education in because it's a firm instead of a person.
Okay, so in summary, your motion is a $1,000 civil penalty for failure to respond and a $1,000 civil penalty for failure to use reasonable skill and care.
That's correct.
And Jeff, did you second that? Thank you. So that's the motion on the floor. Is there discussion? Yes. Steve?
I'm good with the $1,000 penalty for failure to respond, but I'm not. I think it's a two-phase motion, and I just don't think we have enough information to assess a $1,000 penalty. I think this is a landlord-tenant problem that regards refunding a security deposit and the condition of the space and a lot of other things that we don't have information on. So if you have to vote, if it's a two-phased motion and it's got to be yes on both, then I've got to vote no because of the second phase of it.
Or
that makes sense.
Or
unless we decouple it.
You can ask to divide the question, and I'm happy to do that.
Okay, I'm asking to divide the motion.
Okay, so now we're going to have two votes. One is the $1,000 for failure to respond, and a separate vote on the $1,000 civil penalty for failure to use reasonable skill and care. So we'll have two votes on this motion. And each motion or each vote stands alone. It's not predicated on the results of the other. Anybody have a question or concern about that before we vote? Okay, Caitlin, we're going to vote first on failure to respond. If you agree with legal that respondent should be offered a $1,000 civil penalty, you'll vote yes. If you're opposed, you'll vote no when your name is called.
Commissioner Joe Begley?
Yes.
Commissioner Jeff Diaz?
Yes.
Commissioner DJ Ferris?
Yes.
Vice Chair Marcia Franks?
Yes.
Commissioner Steve Gwynn?
Yes.
Commissioner John Moffitt?
Aye.
Commissioner Joan Smith?
Yes.
Commissioner Stacy Torbett?
Yes.
Chairman John Grease?
Yes. So that motion passes. Now the second motion associated with this case has to do with offering the respondent a $1,000 civil penalty for failure to use reasonable skill and care. If you're in favor of that motion, when your name is called, you'll vote yes. If you're opposed to that, you'll vote no. Jeff, before we vote.
I want to make the point. In my mind, this motion is more of a kind of a summary judgment thing. The respondent was given an opportunity to respond, chosen not to. And, I'm all in favor of listening to people plead their case, but if they ignore us and not respond, then I have to assume that the allegations are not uncontested. If these allegations are not true, then the respondent should have responded and pled their case when given this first opportunity. And in my mind, that's how I rationalize this failure to exercise reasonable skill and care.
Thank you. Other comments?
Chairman Grease, I would like to get our council, Anna's thoughts on this.
Thoughts on whether you can assess a civil penalty for violations if they have a failure to respond. I do think it's possible for that to be assessed for licensees as their license. I don't think if it was, for example, an unlicensed individual, we wouldn't have been able to do that. It would be unlicensed activity. My concern is that this complaint is opened against the firm. And so I think it may be a little bit difficult to prove reasonable skill and care against an entity instead of an individual person that's responsible. So if that is something that the commission would like to do, I think it would be well within your purview to administratively open a complaint against the principal broker of the complaint, and then we can assess from there.
I think, Jeff, that might be the thing for us to do. What do you think?
Yeah, I think we should go ahead and put it up against the principal broker of the firm.
Well, let's start with this. We have a second part of a motion that either needs to come off the table or be voted on. So if Marcia, you wanted to remove the second part of your motion.
Yes, please.
And if Jeff wanted to agree to remove it, then we'll have taken care of that issue. So we don't need to vote at any point other than, unless Marcia and Steve, I'm going to get to you in just a second. If Marcia, you wanted to offer a motion about the principal broker at this point, you have the floor.
Yes, I'd like to make a motion that we open a complaint against the principal broker in this case.
And that's for failure to?
For failure to supervise.
Okay. Jeff, you second that?
Supervise, or not supervise, but to respond. Isn't it the principal brokers who should be responding on behalf of a firm?
Typically, it would be a principal broker that would respond on behalf of a firm. But I think you're wanting to open a complaint with the penalty, or are we wanting to open the complaint first and then reassess?
The only reason to open a complaint would be to assess a penalty. So,
right. I don't think then if that was to happen, we'll have to let the complaint be open first and give the respondent an opportunity to respond to the complaint. So we would just need to open the complaint.
Okay, that would be my motion.
So I have your motion, but I'm not sure what's your justification. Failure to supervise? Is it failure to respond? We've already assessed the firm on that one, or offered a consent agreement to the firm.
Or did you want to do reasonable skill and care?
I think what Anna was saying is that we open up a case against the principal broker, and we'll have to have a reason for it. It doesn't really matter to me which one of those it is, but I think it's reasonable skill and care, probably more, since we haven't directly asked them to respond as principal broker, even though they should have for the firm. So I'm good to go with reasonable skill and care.
Jeff? Okay, that's seconded. Now, Steve, you've got the floor.
I've got a question and a point of clarification. Is the respondent the owner of the property? Because it says the complainant rented an apartment from the respondent. So when I read that, I say the respondent owned the property, but I'm not sure that's correct. But that's what it says. So I would ask the question, is the respondent the manager of the property and working for someone else, and all he or she is doing what the owner told him to do, which, I don't know the answer to that. I'm just wondering if the respondent is the landlord. She's talking.
I don't have any information that this respondent is the owner. They are property manager of the apartment complex. So I'm not sure if they're the owner or not.
Don't you think that's a key ingredient of this? A key point is who owns the property, and was the respondent just working for, tough landlord? I mean, I don't know.
Well, if we open a complaint, then the respondent, if he or she chooses to, can reply in any form or fashion with any fact he or she wants to give. At this point, we just don't know.
Right. So
And I would say if the principal broker doesn't respond back, then we have a big problem with a principal broker that won't respond back.
Right. We've already assessed $1,000 for failure to respond. That's already done.
So I just wanted to clarify, when we're administratively opening a complaint, we're not necessarily limited as to what portions of the rules and statutes that we're looking at. So we would be opening a complaint and assessing the situation as applied to the principal broker, and then you would make a determination if they're the owner, those kind of things. Like if that was something you wanted to know, we would need to find out that information, but we don't have to know these things on the front end before opening a complaint.
Well, I don't know. The complainant, it could be confused on who owns the building. And I guess we don't know that because the guy never responded. But maybe this second phase will flush it out, I guess. I don't know.
Joe? Okay. Anything else, Steve?
No, that's it.
Okay. So we're about to vote on a motion that, if passed, would open up a complaint against the principal broker for failure to use reasonable skill and care. If you're in favor of that motion, when your name is called, please vote yes. If you're opposed, vote no. Caitlin?
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Yes.
Commissioner Steve Gwynn,
No.
Commissioner John Moffett,
Yes.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. That motion passes. We're on to number 27. Jeff?
Thank you. The question I had on this one, it seems to have run into this a couple of times before, where licensees are having their identities stolen or their license numbers discovered and being used to defraud customers and clients. Is this something that a case that is eligible to be referred to the Attorney General, kind of let them investigate it or add it to the bucket of things that they're investigating in this matter?
It's not clear that that was the case in this situation. I think there might have been just a mistake by the complainant in naming this respondent as the party that was involved in the transaction. This individual was not involved in timeshares, so it might have been an error by the complainant on the name of the individual, because it was 10 years ago that they purchased this timeshare.
I'd like to make a motion to accept council's
Joe Bagley makes a motion to accept council's recommendation. DJ Ferris seconds that motion. Discussion. If you're in favor of the motion, please vote aye when your name is called. Caitlin.
Commissioner Joe Begley,
Aye.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Frank,
Yes.
Commissioner Steve Gwynn, Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett.
Yes.
Did I miss John Moffett? Commissioner John Moffett,
Aye.
Chairman John Grease.
Yes, that motion passes. We're on to case 28. Jeff.
I'm going to go ahead and move to accept council's recommendation.
Is there a second? Steve Gwynn seconds. If you're in favor of the motion, vote aye when your name is called. Caitlin.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz, Commissioner DJ Ferris,
Yes.
Vice Chair Marcia Frank,
Yes.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes, the motion passes. We're on to case 35. Marcia.
I think you skipped 31, John. I had 31 on my list.
So since I didn't have it on my list, so we've already approved council's recommendation on that. We need to go, if you wanted to discuss it, we need to first reverse our action or reconsider our action on case 31. So we've discussed it.
Who had number 31? It wasn't me. I wrote it down when you read out the numbers to pull.
I don't have it on my list, so let's assume I just made a mistake, but it wasn't pulled out. So we can go to 35.
Yeah, I don't have 31 on the list that was pulled up.
Okay, so number 35. I noticed that the real estate firm license is it expired in November. So I'm wondering, this case was opened in September. So I'm wondering, is this firm still expired?
I believe it's been renewed, but I'm going to double check.
I'm happy to look into that if you guys want to move on to the next one.
Is it clear, Shalina, that the activity that occurred was while the firm was still licensed?
Yes.
Mark.
Okay, then I'll move that we accept council's recommendation to close.
Is there a second? Jeff Diaz seconds that motion. Discussion. Kaylin, if you will, look up, see if that firm has been licensed or is active now, that'd be great. But in the meantime, if you'll call the roll, and if commissioners are in favor of the motion to accept council's recommendation, you'll vote yes. If you're opposed, vote no.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Yes.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes, that motion passes.
I think Anna beat me to it, and the firm did renew, and they now expire in 2022.
Thank you. 36, Marcia.
All right, so number 36, I had a problem with the earnest money was released July 22nd, but it was not received until August 18th, and that was 27 days. But the complaint is against a real estate firm. I make a motion that we accept council's recommendation to close on the firm, but open a complaint against the principal broker for not being timely with the release of the earnest money.
Okay, so we got the possibility of two motions. Is there a second to Marcia's motion, which is in two parts?
Joe raised his hand.
Did you, Joe? Where are you? I don't see you. There you are. Okay, thank you, Joe. So that's properly on the floor now. So we're gonna take this in two votes. Regarding the initial complaint, the motion is to accept council's recommendation and dismiss. If you're in favor of that motion, please vote aye when your name is called. Caitlin.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes, that motion passes. Now, the second motion that Ms. Franks offers, seconded by Mr. Begley, is to open a complaint against the principal broker of this firm. I'll be right with you, Joe. Because he or she took too long to return the earnest money, basically. Joe?
I was doing a second on the first motion, not on this motion, because of that second to the last paragraph. It seems like they all agree that there was miscommunication and email issues, and that the complainant wanted to withdraw the complaint. So,
You didn't mean to second this part.
Joe, you're muted.
I know what he said. So, Marcia, the chair's going to rule that you don't have a second on that second motion of yours just yet. If somebody'd like to second it so we can discuss it, I'm happy to do it. The motion offered that the chair is looking for a second to would open a complaint against the principal broker for failure to handle earnest money properly.
So I guess the question is, does the commission think that 27 days is too long, regardless of what the circumstances were?
And that's what we'll vote on if we get a second to your motion. Is there a second? There is a second. Mr. Diaz seconds the motion. Now we can have some discussion on this, or we can go ahead and vote, depending on what the commission would like to do. Jeff?
Well, I kind of agree with Joe a little bit when, I don't know if these dates are actually when earnest money was released versus received. It could be just a breakdown in technology or communication. It seemed to be that the principal broker met their duty and just acknowledged, or just a technology snafu.
Okay, other comments? All right, since we have a motion on the floor, we're going to vote on it. If the motion is to open a complaint against the principal broker, if you're in favor of that motion because you believe the principal broker didn't handle the earnest money in a timely fashion, you'll vote yes. If you're opposed to it for any number of reasons, you'll vote no when your name is called.
Commissioner Joe Begley,
No.
Commissioner Jeff Diaz,
No.
Commissioner DJ Ferris,
No.
Vice Chair Marcia Frank,
Yes.
Commissioner Steve Gwynn,
No.
Commissioner John Moffett,
No.
Commissioner Joan Smith,
No.
Commissioner Stacy Torbett,
No.
Chairman John Grease.
No. Now, if that motion fails, is there a substitute, another motion someone would like to offer? I sense we'll move on, but let me just say one thing. I appreciate Jeff seconding a motion so that we can discuss it. And that's perfectly appropriate, especially in the eyes of this chair, that if you make a motion to second an item, or you second an item and vote against it, that's perfectly okay. And especially after you've heard discussion, your thoughts may have changed. So thank you, Jeff. And Commission always ought to feel like if it's worth talking about, let's at least talk about it by getting a second going on. With that said, let's go to number 46, Marcia.
Number 46 is the represent, and it is where it's alleged that when the person that was showing property left, they left several doors open. And then the listing agent went by afterwards and found the doors were open. And the new information is that the respondent got the people that they show the property to write a letter saying that the doors were closed. So, that's the only proof we have is that, except that the agent themselves said that they can't recall. So I don't know how the agent is now recalling that they did shut the doors. I just, is that enough for us to to turn around a decision that was made? And the decision was $1,000 for failure to exercise reasonable skill and care. I know I'd be pretty upset if the doors were left open on one of my listings. So I just thought that we should talk about it before we just believe the respondents. Who knows who the person was? It could have been their mama or their brother or something that wrote this letter for them too. So I just thought we should discuss it.
Vice Chair Franks, I'd like to just state that this respondent contacted me and was very concerned once they received that consent order. And although they acknowledged that it could have been possible, they were pretty sure that this had not occurred. The follow-up that I got from the potential buyer stating that the doors were closed was received directly from that potential buyer by email to me. So it was not something that it could have been, fabricated or falsified. It was clear that if the violation didn't occur, that I said to the respondent that they should provide some sort of proof. They were very apologetic and concerned and were sure that those doors were closed when they left. And they knew that there was an issue because of the COVID pandemic, and the seller's wife was a cancer survivor, and they were particularly cautious when they viewed that particular property.
Okay, I'll accept council's recommendation to close.
All right, second by Mr. Diaz. So, Shalina, this consistently irritates me when commission offers a civil penalty and then the respondent decides to produce more evidence. And I'm going to vote with the motion. I don't want respondents in the future assuming that they can give a brief outline of what happened, and if they happen to get a civil penalty offered, then they'll produce evidence that they really want to use. I'm not suggesting anybody's encouraging them to do that, but if somebody were to call you or contact you, at least my opinion is they need to produce their evidence up front and not wait to see what we do before they really get serious about the case. Just editorialize. And I'm not just saying it to you, Shalina, it's just me talking, okay? All right, with that said, the motion is to accept council's recommendation and dismiss this case. If you're in favor of that motion, when your name is called, please vote aye. If you're opposed, vote no.
Commissioner Joe Begley,
Yes.
Commissioner Jeff Diaz,
Aye.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes, so that motion passes. We're on to number 47. Marcia.
Number 47 was me also. So we assessed $1,000 civil penalty for unlicensed activity. And the only new information is that they have subsequently from that taken the necessary certification in Tennessee, submitted an application for licensure, and the license is being processed. So this is totally after the fact of what this case was about. Yes, I'm glad they're getting legal, but they violated and they were found guilty of unlicensed activity, and nothing's changed the information on that. So I don't know why now that they're going through the process and they still don't have a license because it's being processed. And we know it only takes 5.4 days to get it processed. So I'm inclined to disregard council's recommendation to close. And my motion would be that that we maintain the $1,000 civil penalty for unlicensed activity.
Okay, thank you, Marcia. Is there a second? John Moffett seconds that motion. Now discussion. Shalina, anything you want to say on this one?
And I just, the reason I changed, I requested a represent on this is because we have the license application in place, and I believe the fingerprinting issue is the last item, and that they mitigated the unlicensed situation.
This is like after the fact. So, you know, if I get found guilty of robbing a bank and I say, oh, I'm sorry, it'll never happen again. I mean, you know, I did the crime, you know, so I don't see there's any reason just because someone has remorse or they got caught and don't want to pay $1,000 fine that we would change our minds after we gave it thoughtful consideration previously.
Okay, other comments? Steve?
I'm just curious what our success rate is for collecting fines that we find people that are not licensed. I mean, what do we do? I mean, when we find someone that's not a licensee, what do they say? Okay, I'll pay you $1,000. Or they say, go jump in a lake, or what do they do? You can't do it, or or, you know, file a lawsuit against me? What's the comeback to that if somebody says that?
Based on my experience with just the different regulatory programs across the board, in most situations when there's unlicensed activity, the attorneys end up bringing a formal proceeding for the unlicensed activity. They usually do not just accept the consent order and pay the fine or pay the civil.
So we're having to spend state money by time with attorneys and whatnot to try to collect $1,000. Is that, I mean, do we spend $2,000 to try to collect $1,000? Probably.
I'm not sure of the exact amount, but yes, in terms of filing the case and attorney time and there's things involved, yes, there probably is an expense in bringing those.
Well, to me, this is not about the money. This is about a deterrent, because unlicensed activity is probably our number one complaint that we get, and we just can't cave in to this. I think if we hold the line on anything, my two big things I want to hold the line on are unlicensed activity and abuse of an escrow account. To me, those are the two biggest things that we see that they hedge on crimes most times even. So I want us to keep us a strong face from this commission that, you know, we're not gonna have unlicensed activity in this state. And if you do it, then you're going to pay $1,000, and especially if you want to get a real estate license in the future.
I'm just glad that they're getting a license. You know,
Okay. The motion on the floor is to reconfirm the commission's previous decision. If you're in favor of that motion, you'll vote yes. Not reconfirm it, to confirm the commission's previous decision. If you're opposed, you'll vote no. Joe?
One question. Will this show up on their, if they get a license, will any disciplinary action show up on their file, or will their file start brand new when they get their license?
There will not be any disciplinary action on their file because this will be closed, this complaint, and their license will be clear.
Thank you.
Okay. Once again, the motion is to confirm previous action of this commission and stand or stick to the $1,000. Was it $1,000? I'm getting ahead of myself.
Yes.
Thank you. Stick with the $1,000 civil penalty previously offered. If you're in favor of that motion, you'll vote yes. If you're opposed, you'll vote no. Caitlin?
Commissioner Joe Begley?
No.
Commissioner Jeff Diaz?
Yes.
Commissioner DJ Ferris?
Aye.
Vice Chair Marcia Franks?
Aye.
Commissioner Steve Gwynn?
yes.
Commissioner John Moffitt?
Aye.
Commissioner Joan Smith? I'm sorry, Jonah. Did you say aye?
I did say yes.
Commissioner Stacy Torbett?
Yes.
Chairman John Grease?
Yes. So the motion passes. We're on to number 52.
I don't know who all else was on this one.
I'm on it.
Okay, so this one is the only the commission gave authorized a formal hearing, assess civil penalties in the amount of $2,000 for failing to diligently exercise reasonable skill and care, and also improper, fraudulent, or dishonest dealing which those are very serious offenses also. And the only new information is that the respondent is requesting a hardship consideration for the civil penalty to be reduced. So number one, this would be like a precedent setting. We've never been asked this before, so this would be setting a precedent if we allow it. And the respondent admitted their guilt. So I'm wondering what is the hardship and why would we consider it? And I know that Shalina has down here no recommendation, just a discussion. So Shalina, what's the hardship?
Apparently, this respondent contacted me and stated that they were having financial difficulties, and I'm not sure if it's related to not being able to sell homes or not clear exactly what the situation is, but they requested a hardship with request from the commission to pay the civil penalty for the violation.
Why are they unable to sell?
I am not aware of the details or circumstances concerning if they're able to sell or not, but they are having financial difficulties. Meaning this respondent wants to sign the consent order and pay a civil penalty, but they cannot afford the civil penalty that was assessed.
So I will make a motion that we deny the respondent's request.
Second.
Second by Steve. You know, this was the case where the respondent admits smoking dope, but not on the job. I mean, if you go back and look at the narrative here, it just makes no sense to me that all of a sudden he's going to come or she's going to come to us and say, hey, I can't afford to pay. So I think in the past, Shalina, I think, but I could be wrong on this, sometimes terms are offered to pay the civil penalty. Have you heard of such a thing?
Yes, we do offer a payment plan situation with limited term, because obviously we don't want this to be dragged out for too long. The respondent was not open to any sort of a payment plan.
Okay, thank you for that. The motion is to confirm our previous action, or let's say confirm our previous action.
Yep. Chairman.
Joan.
So Shalene, so you did offer a payment plan at the time of discussion. Is that what you're saying to us?
Yes, ma'am.
And she rejected that. She just wanted the payment to go away.
The respondent just made a request if the commission would reconsider the amount as a hardship consideration.
Okay. Did you specifically give the payment plan, or you just asked, were you interested in a payment plan?
I didn't give the terms of the payment plan, but I did offer a payment plan of up to 6 months to spread those payments out.
Okay.
And a civil penalty is a hardship on every licensee that we give a civil penalty to. Every single one. So this smacks in the face of all those thousands and thousands of people who have paid their penalties.
Okay, I think we've had enough discussion. If you're in favor of the motion, which is to confirm our previous action, you'll vote yes. If you're opposed, you'll vote no. Caitlin?
Commissioner Joe Begley?
Yes.
Commissioner Jeff Diaz?
Yes.
Commissioner DJ Ferris?
Aye.
Vice Chair Marcia Franks?
Aye.
Commissioner Steve Gwynn?
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. So Shalina, just one follow-up. So let's just say this respondent says, well, I can't pay, I'm not going to pay. Then they've not accepted the consent agreement. Is that correct?
Yes.
So at that point, then we schedule a formal hearing.
Yes, it would be prepared for a formal hearing. Correct.
Okay. Thank you. Okay, number 55, Marcia.
Okay, so this one, we gave a civil penalty of $1,000 for failure to diligently exercise reasonable skill and care. And we deferred it to the next commission meeting for more information from the principal broker. And the principal broker sent the information that this principal broker has had a sit down with the complainant on several occasions over the years and counseled the complainant about communication and ethics, and that they have broker released the person. So I see no reason to rehear or talk about the information that we found them guilty on for the reasonable skill and care. And so it's too late for any. This principal broker did the right thing by responding back to us, but it doesn't give us any information about why this person shouldn't be found guilty of this misconduct. And this is opening the door to every complainant being reconsidered. And the time for the info has passed on this one. And so it would be my motion that we do not reconsider the $1,000 civil penalty that we have in place.
Vice Chair Franks, I believe my instruction was that this would be deferred to obtain the additional information, and then you would consider my recommendation. So there might be a need for the commission to consider the recommendation and have a vote on the original recommendation I made based on this additional information I'm presenting.
So
yes, I'm sorry about that. We deferred until you got more information. So we had the recommendation was to authorize the $1,000, and now you're saying to close it. This is not against the principal broker; it's against the affiliate.
I'm not saying to close this. I'm just asking for consideration of the original recommendation.
Okay, so my motion would still be $1,000 civil penalty for failure to diligently exercise reasonable skill and care in providing services to all parties to the transaction.
Seconded by Jeff Diaz. One thing, Shalina, I didn't see this, but I didn't read it carefully, perhaps. Did the broker release this complaint?
Yes, they released the complainant, not the respondent.
Okay, I just didn't see. I'm happy brokers use that unilateral authority to get rid of problems. Okay, so the motion is to offer the respondent a $1,000 civil penalty. Is that right, Marcia? Not the complainant, but the respondent.
That's correct.
Okay, and Jeff Diaz seconded that motion. Now discussion on the motion.
A question. I should have asked it on the last case, but is a fine penalty dischargeable in bankruptcy, or do we know that? Do we know? Has that question ever been asked? I mean, if somebody don't want to pay a fine, they can just say, "Fine, I'll fine Chapter 11," and it goes away, or what?
I'm not sure about that. I haven't ever had that situation. Maybe Tony Glandorf or Anna might be able to chime in and know.
I've never had that question come up before, But I do know if we have issues with collecting payment, we do send the respondent and their complaint to a collections agency. And so whether that's dischargeable, where you can discharge that from bankruptcy or not, I'm unsure.
Yeah. So this is Tony Glandorf, one of the chief counsels here at regulatory boards. That's correct. We send those out to collection agencies to collect those. We have a contract with the collection agency. Any civil penalty less than $10,000 goes to them, and they make attempts to collect those. And at some period of time, if they're unsuccessful at collecting those, generally what happens, there's a process by which those debts can be written off by the department through the commissioner's office. To the question of bankruptcy and being non-dischargeable, I don't believe that those are non-dischargeable, but I think there's a priority. They would take priority over other debts. But I have not seen a bankruptcy matter regarding a civil penalty at this amount be an item that we've dealt with in the 11 years I've been here.
Perfect. Thank you.
Thank you.
Okay, I'm going to go back to the motion just for a second. So this was an in-house complaint. I mean, a licensee at a business files a complaint against another licensee at the same business. And it's my understanding that the broker released the complainant, not the respondent. So just on that little bit of information, it's hard for me to believe that it was the respondent's fault. What do you think about that, Marcia?
I think you're right. Now that I'm thinking about that way, I think you're right. All right. So can I withdraw my do I withdraw or do I restate my?
You can take, well, if you and Jeff agree, we'll take it off the table, put another motion up there.
Is that okay, Jeff?
I just want to make sure I understand. So since the broker released the complainant, there was no further obligation on behalf of the firm or the licensee?
Well, the only mitigating factor I have is this is an in-house problem. It doesn't necessarily relate to consumers or clients, the public. It's two agents complaining or not at odds with each other. And the referee, the principal broker, said, "You're out of here," to the complainant. That's why I want. That's how I base my decision.
Okay, I'll accept the new motion.
And my new motion would be to close this case.
Jeff seconds that motion. Is there discussion on that motion? Joe? Okay. All right. Since you're ready to vote, if you're in favor of the motion to dismiss, please vote aye when your name is called.
Commissioner Joe Begley.
Aye.
Commissioner Jeff Diaz.
Yes.
Commissioner DJ Ferris.
Aye.
Vice Chair Marcia Franks.
Aye.
Commissioner Steve Gwynn.
Aye.
Commissioner John Moffitt.
Aye.
Commissioner Joan Smith.
Yes.
Commissioner Stacy Torbett.
Aye.
Chairman John Grease.
Yes, so that motion passes. And unless Shalina's got some more she wants to add to the list, that completes the consent agenda.
No,
I hope you don't.
no, I
Thank
have
you.
nothing more to add. Thank you.
And I haven't said this recently, but anybody that has the patience to compile these cases and try to summarize them in an orderly fashion has got my everlasting, let me put it a different way. It's nothing I could ever do. It's a special skill. Thank you for what you do. All right, we have one more item that I know about under the commission discussion. Marcia Franks had a nomination for the Bill Toon Award. Marcia?
Yes. I'm going to hold this book up, and I hope that you can see. Can you see John Giffen there?
Second.
Everyone?
Second.
John Giffen wrote this book. Everybody still needs to buy this book. John passed away a couple of weeks ago from COVID. As a commissioner, I was seeing over and over and over, we were giving education to people as a part of their penalty. But when it came to principal brokers, it was like, what do we give them? And so John is, well, let me just tell you, John is an award-winning real estate broker, manager, agent, author, and real estate educator. He is director of broker operations for Benchmark Realty, one of the fastest growing independent real estate companies in North America. John is a Tennessee Real Estate Commission approved course provider and instructor, as well as the author of several continuing education courses on real estate. He also does a lot of writing for like Inman News. And when I knew that we needed help with our principal brokers, I called John because I think he does a great job of teaching and writing classes. And with his experience, what he actually does is he started out as principal broker at Benchmark Realty, and then they opened up several offices. So he was in charge of all of the principal brokers and make sure that they were doing everything that they needed to do. So I went to John and I said, John, what if we did a core class for principal brokers? And let me tell you, this problem with principal brokers is worldwide, or at every Arello meetings, this is a problem that comes up. What do we do about principal brokers? And Tennessee is the only state that has this principal broker core class. I've started having lots of people asking me about it. John did this class through the Tennessee Realtors Association, and it has been very well received, and he just did a great job. I met with him several times as he was compiling the class. He wanted to get it right, and in my opinion, he did get it right. And even today, John's not with us today, but honestly, bless his heart, he would watch these real estate commission meetings every month so that he would know what was going on. And the Bill Toon Award, I looked this up, and this has John's signature on it about the Bill Toon Award. And it's for, it suggested that they have a minimum of 10 years experience and that real estate and real estate education experience. And John is just everything and exemplifies the type of person that should receive this. It's called the William C. Bill Toon Jr. Award for Excellence in Education. You know, he's just one of those guys that whatever you needed, he was there to help you. And the title of the book is, Do You Have a Minute? This is what he would walk by the doors of his agents and say, do you have a minute? And he was always checking on people and making sure that everybody was well equipped and had everything that they needed. And for these reasons and many, many more, I would like to nominate John Giffen for the Bill Toon Award for Excellence in Education.
Thank you, Marcia. Did you get a second to the motion? We'll determine logistically how to get that award presented. But today, if you're in favor of the motion, vote yes when the name is called.
Okay, Commissioner Joe Begley?
Yes.
Commissioner Jeff Diaz?
Yes.
Commissioner DJ Ferris?
Aye.
Vice Chair Marcia Franks? Commissioner Steve Gwynn?
Aye.
Commissioner John Moffitt?
Aye.
Commissioner Joan Smith? Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. Thank you, Marcia. Thanks, DJ. So, I'm getting terrible feedback. Anything else?
We do have one more thing.
Oh, darn it. What is it?
Under legal, there was a note to re-go over some rules.
I
Dang
feel
it.
like it was skipped on purpose. Was that the intention?
So, and I'm shocked you would even ask such a question.
She's over there yawning in front of the camera.
All right, Anna, go through this thing. And I know it's, go ahead, Anna. Let's do it.
Okay, so first I want to explain what happened. So the rules that you have before you are the rules concerning criminal convictions, which we just had a rulemaking hearing about. But once we got the rules back, we noticed that there was an error in the drafting of the rules. So our intention was to incorporate the segments from the Fresh Start Act to make sure that our statutes match. And there are a few things that we left out. So if you look at the red line quickly, you'll see that the amendments are very similar. So in 1260-01-.015, instead of saying Class A, B, or C felony, this was amended to saying offense enumerated in TCA Section 62-76-101 B4B. So that is just a direct citation to the Fresh Start Act. And the change that you'll see is actually the one that comes in the next, where it says, or a felony and or misdemeanor involving theft of money, services, or property. So previously, before, we had cut out felonies that this would have removed felonies that related to theft that were in Class D and E felonies. So we put that back in there to make sure that we still get those individuals to appear before us at the commission. So just to make things quickly, it used to say A, B, and C felonies. That was not enough, so we included the citation, and I decided to add in just in case felony and or misdemeanor to make sure that we get those individuals that have felonies for theft. So there are Class D and E felonies related to theft, and those would have been removed before. So we'll need a motion to approve the rules and for us to proceed with a rulemaking hearing.
So moved.
So, would the rulemaking hearing be today?
No.
Thank you. So today you just want a motion that Jeff has already made that would authorize us to proceed with the rulemaking hearing.
Correct. So I will take this in the vote, have it go through our memorandum process here in office, and then it'll go to the governor's office for pre-review, and then we'll set a rulemaking hearing within 52 days. So it probably won't be until March or April.
Okay, Joan Smith seconded that motion, whether she knows it or not. Any discussion? Marcia?
I'm just trying to find 62-76-104.
Stand
So
by.
that statute's not going to be in your green book. It's
Okay.
the Start Act, which is going to, Chapter 76 is another chapter that you don't have access to.
Okay, thank you.
Okay, I sense no need for discussion on this, but does anybody want to discuss it? Okay, the motion is to start the rulemaking process, for lack of a better description. If you're in favor of that motion, vote yes. If you're opposed, vote no. Caitlin?
Commissioner Joe Begley, Commissioner Jeff Diaz,
Yes.
Commissioner DJ Ferris,
Aye.
Vice Chair Marcia Franks,
Aye.
Commissioner Steve Gwynn,
Aye.
Commissioner John Moffett,
Aye.
Commissioner Joan Smith,
Aye.
Commissioner Stacy Torbett,
Aye.
Chairman John Grease.
Yes. Okay. Regarding tomorrow and regarding last month, many of you have never had a formal hearing or been privileged to be a part of one before. Do any of you have questions, things that struck you as odd or you don't understand that will reoccur tomorrow? Any thoughts or comments or questions, just generally speaking about the process? Marcia?
So I've been through a whole lot of these, but they've always been in person. It obviously takes more time when we're doing it on a WebEx. And I am wondering why we scheduled 2 in one day. I know last month we thought that it would take an hour and a half, 2 hours, and it ended up taking 9 hours. And even with the ones tomorrow, there's no way of knowing what evidence will be put on or how much time it will take. There's really no guessing it until it comes in, and it depends on the attorney, it depends on the judges. So I'm wondering, why would we schedule 2 in one day when the first one, what if the first one's not over until 6 p.m.? Do we still do the second one?
Don't you get the sense if they're 2 in one day, Marcia, they must be very short?
We thought last month's was also.
No, I don't think we had an hour and a half or 2 hours, but nobody had an expectation, including the lawyers, that it'd be 9 hours. It's just stuff happens. So,
but this is the first time in my 6 years that we've had 2 in one day. So I'm wondering, is there a reason that we're doing that?
So I'd like to ask the commission a question. What happens? We only have, if there's a matter that is before you that the commission sits, those are going to be the dates that we give the Administrative Procedures Division in advance. And technically, I believe, Shalina, correct me if I'm wrong, but we give them the actual meeting date and the date following. So if it would be your preference to not schedule 2 hearings on a Friday and then one after our meeting, like we take lunch and come back afterwards, that's also an option.
So another way of saying it is we could take about a 20-minute break for lunch right now and have a hearing, which might take us to dinner. Might not. Or do you prefer to keep all formal hearings on a separate date? That's really, and so far the preference of the commission over the years has been to keep it on a separate day because you just don't know how long it's going to go. Now, Marcia is correct. I don't recall ever having 2 on one day. But sometimes, especially in this period of time, getting them scheduled at all is pretty dang tough and has been tough for us.
I might let somebody in legal speak, but there are many other programs in the department that do more than 1 in a day.
That's correct.
And I don't think that they would hold you hostage. I think if the first one goes until 6 p.m., like it did yesterday, or even if it goes until 5, I think the second one could be continued or moved if it's not reasonable to complete both.
Yeah, typically the administrative judge will set it for the next day if it's gone too late, meaning the first hearing has gone too late into the day. They'll reconvene the following morning and either resume the hearing that wasn't completed or start the new one if there's more than one.
Stacy.
Is there a hard stop for these? That last one was still going, and here in Eastern time, it was after 6 o'clock. So what happened? I mean, can it go on until midnight if we don't stop, or do we have a hard stop? Because that was a little difficult, at least for me, because I was supposed to go to a birthday dinner for myself. and I couldn't go. I did go late. That's why I switched to the phone. But it's hard when it's open-ended and we have no idea if there's going to be a stop, especially with that being on a Friday. So I just didn't know, is it going to be an end at 5 Central for sure, regardless of where we are, or are we going to keep on going?
And do we even have the right to say to the judge, it's 5 o'clock and we want to reconvene at another time? Because the judge may have something the next day, or hey, we might have something the next day that we can't miss, and then we wouldn't have a quorum. And in the middle of a hearing, I don't know how we would walk away from it in the first place. And so I would say in the future, to keep this from, hopefully it won't be a problem tomorrow, but we have no way of knowing that right now. So I would say never schedule more than one in one day. If we had to have we had a backlog and we had to reschedule some, it would be easier for us to decide what would be a better day for us to come back than it would be to just come back the next day, because everybody has plans for the next day.
Typically the administrative law judge will decide how long you go, but certainly the chair and the commission can make a request at the start of the hearing or during the hearing, in fact, to request that the hearing conclude at a certain specific time.
John, I think it'll be interesting tomorrow to see. We got a new judge. Just my observation, it seemed like we did spend a lot of time with bandwidth issues. He tried to have that background for a while that blew up, and other things that were going on relative to, trying to have a trial essentially over WebEx is not granted it's not an easy thing, but maybe this judge tomorrow will have a little bit more streamlined approach, and we'll see how it goes. I've got one quick question of legal. It's unrelated to what we're talking about. So at the right time, I'd like to ask a very quick question.
Okay, any other comments or questions about formal hearings? Y'all need to be optimists tomorrow and assume they'll both click off quicker than you can imagine. DJ.
Just to offer a moment of brevity for each of you commissioners, I wanted to seek your congratulations after taking the bar after last month's meeting and formal hearing, and I successfully passed.
Wow.
Thank you, DJ. Steve, let's
congratulations. That's all. We need another attorney, and then we'll
I'm kidding. I'm kidding. I did not pass the bar.
Yeah.
You get that. Not making light of our council's achievements, but I felt like I could have set for the bar after that hearing.
Steve?
This is just a quick question for the attorneys. When we're fielding complaints, are the conversations tape recorded? I don't know if I've heard the answer to that, or just curious.
What
Do you mean in the meeting?
Beg your pardon?
I was asking if you meant like during the meeting when you're discussing complaints.
No. When a complainant calls into the Tennessee Real Estate Commission and they're explaining their problem, is that conversation recorded?
So primarily our complaints are filed online via our complaint form, or they're mailed in. If somebody was to call requesting a complaint, we would walk them through how to file a complaint. We don't take it over the phone.
So all that detail is written out, is about who shot John. Is all people are writing all that much information?
They're either writing it or they're providing supplemental documents to go along with their complaint. It comes in as a complaint from the complainant, and then it's sent to the respondent. So you're getting at least the respondent and the complainant's response, any
In one-
documents that
got
they.
it.
Mhm.
Okay, thank you.
And
If there are any conversations with either party, are those recorded or it never happens?
We only get what is provided to us. So if I don't think it's uncommon for complainants to include text messages or emails that they had with the respondent, that sort of thing. So if that's submitted, then it's included and summarized for you. But we only have what is either provided from the complainant, the respondent, or what is gathered from an investigation if an investigation is done.
All right, thank you.
And let me just add, sometimes in some of these complaints, there's a tremendous amount of supplementary documents that are included or attached to the complaint form and the response that have to be reviewed. And as Caitlin said, sometimes there's text messages and email chains that are also included, and photographs and various other information. There are times when I have to reach out to the complainant or the respondent to get additional information, and I typically do that by email, not by telephone. And whether or not they provide it is, a different story. But in most cases, they do provide the additional information.
Okay, thank you.
Marcia.
And also, I wanted to be clear, last month's meeting, because Anna was presenting the state's case, we did not have her to ask advice of. So tomorrow, at tomorrow's hearings, Anna is not presenting. Number one, is that correct?
Mhm.
Okay, so Anna, will we be able to ask questions of you when we need directions as far as the law?
So, if it's during the hearing, no. But if you remember towards the end, we had a specific question. Judge Hilliard did allow me to answer that question for you. So I only have the first case, but I will be here for the second case to answer questions. So if you have a specific question, I would urge asking the judge, and then they'll make a determination who can answer it.
So Anna, you're presenting the first case?
Yeah, either first or second, I'm not sure, but one of the two.
Okay, any other questions, comments? Steve, earlier I was bragging about Shalene and her staff putting these cases and condensing information down to a paragraph or a page, whatever it may take. Just picture getting information from 10 or 12 different sources and trying to collate that all into a narrative.
Unbelievable. Yeah. If you're getting into text messages and back and forth emails and all this, I take my hat off to you ladies to be able to put it down in a one sheet, much less a few paragraphs.
All right. With that said, unless there are any other comments, Jeff.
Would it be too soon to ask to be excused from the hearing tomorrow?
Hey, I will tell you this one funny story real quick and then we'll be done. When I first got on commission, we had a commissioner who, when the judge would go around the room to the commissioners and say, do you have any previous knowledge of this case? This commissioner would invariably raise his hand and say, I do, Your Honor. And he would be excused at that point, and he'd get about a day's head start on everybody else trying to get home. So don't be pulling that trick anymore. We're on to it. Unless you do have knowledge about the case, you got to participate. All right, we're going to be in recess until 9:30 Eastern Time, 8:30 Central Standard Time tomorrow morning. Thanks, guys. Appreciate your participation. Bye-bye.